Thank you for the wonderful panel last session. Welcome to this panel. It's the interconnections between animal law and tribal law. My name is Jessica Chapman. I am the Criminal Justice Fellow with Animal Legal Defense Fund, and I'm also an adjunct professor with the University of Pittsburgh School of Law. I also, just for complete transparency with particularly this presentation, I just want to let you know I'm not a member of a tribal nation, but I'm an advocate, an ally, and always learning. And before we get started, I'd like to give a special thanks to our presenting sponsor, Carroll House Furniture, our platinum sponsor, the Brooks Institute of Animal Rights, Law and Policy, and our gold sponsors, the Stray Dog Institute and Beyond Meat. This session will explore the interconnections that exist between animal law and Indigenous law, and ways that attorneys who focus on animal law and environmental law, and really any social justice type of law can advocate for Indigenous nations through their work. Now, I'd like to introduce our virtual co-panelist. Her name is Gussie Lord, and she is the managing attorney of Earthjustice's Tribal Partnerships Program. In May 2019, Gussie joined Earthjustice as a senior attorney and its first director of tribal partnerships. She's partners with Earthjustice regional office staff to increase capacity and expertise in Earthjustice's critical work on behalf of tribes and Indigenous communities. Gussie has spent most of her career representing tribal governments, individuals, and Indigenous-owned businesses. Prior to Earthjustice, she was with a small law firm in Washington, D.C., specializing in environmental law. And she has represented different Indigenous nations as clients in federal, state, and tribal courts and administrative proceedings, and has helped her clients develop and enforce their own environmental laws and regulations. She is also a member of the Oneida Nation of Wisconsin. Also, before we get started, I wanted to let you know I'll be using the term Indigenous because from my research and advocacy efforts, it seems to be the most accurate term for a collective entity of all of the myriad Indigenous nations of what is now called the United States. But if anybody is part of an Indigenous nation and you believe that there's a better term for us to use, or there's a term that you would prefer us to use for your nation, please let me know after the presentation, and I would love to talk to you more and find out what would be more accurate. Also, I wanted to thank Chris Green's land acknowledgement. Thank him for his land acknowledgement last night. We all at ALDF recognize that it's a first step in preventing the erasure of Indigenous peoples from collective history, and also moving forward to create a workable future that does create peace and reconciliation and collaboration for us all to work together. Everyone who has a relationship to the U.S. has a responsibility to learn about the U.S.'s commission of forced removals, mass genocides, and cultural extermination, as well as countless crimes against Indigenous nations, and they still impact Indigenous nations and their members today. Also, advocates and allies, who I all hope you will become if you are not already, have a responsibility to bring awareness and solidarity and learn from our individual and collective histories about the best ways that we can support Indigenous nations and their members, and also advocate for animals in the same vein without conflating or objectifying different populations, and bring everybody together in a way that does create that solidarity as we have for this conference. And lastly, we recognize there's so much more that we need to do to improve our recognition, relationship, and advocacy efforts with Indigenous peoples. We hope that this panel is one more significant step that positively and instructively influences relationships between Indigenous peoples and advocates and attorneys to a more workable future. So I also wanted to start out this presentation with introducing you to Seeding Sovereignty, whose founder is Janet McGillivray. Unfortunately, she wasn't able to be here for circumstances outside of her control, but she and her members of Seeding Sovereignty have played a critical role in the reason why we're at this presentation today. Seeding Sovereignty is a multi-lens collective. It works to radicalize and disrupt colonized spaces through the land, body, and food sovereignty work, community building, and cultural preservation. By investing in Indigenous folks and communities of the global majority, they cross the threshold of liberation together. Ceding sovereignty is the result of incredible journeys that Janet went through with various Indigenous nations and tribal communities, including in South America. And it is also female-led, Indigenous-led, and queer-led. They have truly values that are the same ones that align with so many of the missions and values that people within the animal law movement prioritize. And so I really hope that you will come and research them in more detail. Also, just so you have an idea of the different projects that and efforts that they do, they focus on reproductive justice, mutual aid, missing and surviving Indigenous peoples, which is an incredibly challenging issue in current times, climate justice and community security, particularly because these are also such trying issues given the situations that Indigenous peoples and nations find themselves in from coast to coast in different countries. They also work on food sovereignty and ancestral acres and farms, and they create gardens within tribal communities and on reservations for a level of agency and autonomy, and also to be able to protect themselves from any food scarcity issues. And then they also focus on youth and thrival, as they claim it, and leadership initiative. We met with an incredible array of her members last year, and they were young, aspiring students and activists. And I feel like we can all learn from everything that they had to say. And they also have a Medicine Wheels Indigenous Youth Program, which allows people on reservations and community members and Indigenous Nation members to build community in a way that may not have been available during COVID because of the isolation that happened and all of the health issues and risks that came because of COVID. So she would have presented on that today, and I don't want to take that away from her, but she also definitely needs to be part of the conversation because she was the impetus for this tribal as well as her team members. So in that, what are the circumstances that led to this particular presentation? So we met with Ceding Sovereignty last year, and for the entire conference, we talked to them about the different ways that animal law and Indigenous law and Indigenous advocacy can align, but also the ways that they differ, and sometimes, particularly within the animal law movement, as much as we advocate, some of the things that we can do are sometimes injurious to members of Indigenous nations. But we had really collaborative discussions, and I think it was a really important, significant step in finding a way of creating a future where we can uplift advocates and those that we're trying to advocate for within the animal law space, as well as with Indigenous nations advocacy. I'm going to read these questions because I want them to sit with you for a little bit. And I think that they're really important because I know we're all animal advocates here, but we need to broaden our perspective also on how our movement and our work also affect other social justice movements and specifically First Nations. The first question that really came from these collaborative efforts during our meetings last year were, why does animal law exist without a larger representation and stronger considerations for Indigenous peoples and Indigenous nations? That then moved on to, why does animal law, in some circumstances, feel oppressive to Indigenous peoples, their rights, and their needs? That continued on then to, how does animal law consider the different histories, traditions, cultures, and perspectives of Indigenous peoples compared to those of Western cultures? Specific to the US, though, this is really a question for all countries that came from colonization and interacted in a pretty detrimental way. That's an understatement with Indigenous nations and tribal communities. Are, how does animal law account for the trauma and mental health issues that arise for Indigenous peoples, and that can be attributed to their relationship to the US federal government, states, and their policies? Then, how can animal law be used as a tool to support and advocate for Indigenous peoples and animals simultaneously? How can animal law exist within social justice otherwise? How can advocates for Indigenous peoples and advocates for animals work together to uplift each other's missions and the communities each advocate type strives to support? And then lastly, and this is where we're at this point, at this juncture, and it's a lot of unknown space that we're trying to work through and grapple with, is how do we do this work while recognizing and appreciating differences we all bring to the table, and that sometimes beliefs and policies don't always align. That's what these conversations are about. I am working every day with my team and ALDF and advocates to try and find answers for this, but really this is open to the table. There isn't a right answer. And anything that's thought-provoking and uplifts everybody is not going to be a wrong answer. We have to work together to find that space and move forward to find out how we can advocate in the best way possible. So I wanted to give you a little bit of background information on Indigenous nations among what's now called the United States. This isn't inclusive, and I apologize for the generalization because every nation deserves their own respect and acknowledgement of their unique history. However, when you're looking at what is now called the United States, and the way that different communities are racialized, particularly within geographies and the impact that that has, sometimes that collective population and census analysis is what is a big factor in advocating for rights when you're working with the federal government. So as of today, there are 574 federally recognized tribes or nations. That doesn't include the Indigenous nations that haven't been recognized by the federal government, but that still exist and have thriving communities and cultures and legal systems and have been here long before the United States was. Where those federally recognized tribes are on 326 federally recognized reservations. These are places that Indigenous nations have been forced and removed to through forced relocation, but they do cross 56.2 million acres of the United States. That is a significant amount and one that we cannot and should not and never should have ignored. And then there are 3.1 to 8.75 million Indigenous peoples and members of Indigenous nations. Different population analyses and statistics, and depending on the sources, have different calculations for that, but that's a range, but 8.75 million is significant and important in a population that we really need to acknowledge. 20 to 30% of those members and peoples live on reservations, but there are also so many Indigenous nations members who live in every single city of the United States. Looking at populations alone on reservations isn't enough, and it really doesn't create the whole picture. The complications, though, that come in with this whole dynamic and this perspective is that the United States government was an imposition. It was a forced governmental system on Indigenous nations that had legal systems of their own. And so what you see now, this relationship between tribal governments and the US federal government, isn't something that they consented to. It happened through a long history of treaty rights and also just impositions. At this time, the way that it is set up is that though Indigenous nations should not be considered states or considered equal to states and state sovereignty, the US federal government recognizes them as such. Those who write the rules win the game. And unfortunately, the United States in that case won the colonization battle. And so at this time, Indigenous nations have a very specific relationship to the United States and federal government. And though the aspiration and the expectation originally was that Indigenous nations and their jurisdictions within their reservations have the equal rights and the ability to govern their lands alongside and separate from the states, that is not always the case. But the federal government's jurisdictions do overlay onto reservations, and you'd see that through like the USDA or the Food and Drug Administration. And lastly, though Indigenous nations are their own independent sovereignties, the way that the Supreme Court has ruled different cases and opinions, and also because of the people that were in charge and a way to maintain power and control, and through a lot of different exceptions through recognition of Indigenous nations' rights, states are still able to impose their jurisdiction on Indigenous nations. So in the end, it's a big spaghetti bowl of complication. And in fact, the nutshell book for law on this is 500 pages long, and there's a rule and about 20 exceptions to those rules. I encourage you all to read it. It's very informative. And lastly, and this is also something that Chris brought up yesterday, is that we have to remember that traditional and cultural relationships with animals and the environment are distinct to each Indigenous nation. And they're also oftentimes much more respectful, conscientious, and One Health focused than a lot of Western cultures were. And so when we're working in advocacy, we have to remember that the reasons why we have animal law and animal movements as they are today with Western cultures may not be the same issues that Indigenous nations focus on. And so we need to understand that the activism that we do needs to translate in a way that is culturally sensitive to Indigenous nations. This is just an imagery that I wanted to show you of a collective census image of the United States. The states that are darkened in blue have higher populations of Indigenous nations and their members. And so I think it's a really great illustrative point that we can't erase history. We never should have. And this idea of cultural or racial and suggestions with racial undertones that Indigenous nations are no longer present is something that is abominable, and we can't work that way forward. So all of the work that I do is really focusing on advocating in every single state and with all the myriad Indigenous nations that belong to those states to advocate for their welfare, but also improving the welfare of animals. To give you a little bit more background on my end, I'm with the criminal justice program, as I had mentioned. That means that the work I do is very different than the work that Gussie Lord will do, and she'll be able to explain that in more detail. I focus on animal cruelty. I also focus on ways of the criminal law and criminal justice systems work within states, within the federal government, and within Indigenous nations. Got to do it respectfully. But the issue that happens a lot is that particularly with states, is that there are state cruelty codes, and those go over states. They're not part of Indigenous nations. However, there are some bills that are being passed, and because of Supreme Court precedent that are through the federal government that allow states laws to extend into Indigenous nations jurisdictions. This completely undermines the whole belief and expectation that the original relationships between Indigenous nations in the United States started with this idea that they were nations alongside each other. Now, states have the ability to impose their jurisdiction through several different crimes acts and major acts, and I'd be happy to talk to you about those after the presentation. I just don't have time for them now. And I would also argue that particularly with criminal law, because that's something that that is really meant to stay within Indigenous nations. With a recent Supreme Court precedent, I would argue that with enough manipulation, there would be states that would be able to actually impose their animal cruelty laws on Indigenous nations, which at first glance, you think the protections of animals is wonderful. However, the point that goes against that is that means that Indigenous nations agency and autonomy are no longer present. The ability for Indigenous nations to create their own laws and rule their own peoples and their governments is completely undermined with the authority that the state imposes. And lastly, because so much of legal systems and structures of Indigenous nations were exterminated in a lot of ways through forced removal and relocation through reservations, many Indigenous nations had to rebuild their governmental systems, particularly when they were along multiple different Indigenous nations within the same reservations. Through that reconstruction, and it was unique for each Indigenous nation, the federal government supplied language and model ordinances and model legislation that Indigenous nations could use. Unfortunately, this model legislation doesn't actually acknowledge the values that many Indigenous nations have for their beliefs, their traditional values, their cultures that are present and ever growing and expanding. And so what happens is Indigenous nations are forced to adopt legislation that they don't believe in, and that winds up ruling their jurisdictions, and that shows the value of federal governments and states, but actually doesn't advocate or help for their peoples or particularly the animals on their reservations. So our focus within criminal justice is to really address this issue, and while of course protecting animals, also protect humans and nation members in a way that really looks at the whole picture. One, health is this perspective where you're looking at the health of the ecosystem, the animals and the people, and they live together. And it also means that a sickness or an illness for any one of those points creates a sickness or illness for the others. And so if you have anyone suffering in one part of this ecosystem, everybody suffers. So looking at that, we're trying to address federal government impositions and of course complying with law, but in a way that promotes self-determination and agency for Indigenous nations. We're also looking at cruelty as a way of saying, is this actually intentional, or is this a lack of access to resources? Are these poverty issues? Are there mental health concerns? Are there lack of access to veterinary care? Is there something that we can do to advocate for you to increase the needs and the rights that you deserve to be able to give care to animals? And also saying that perhaps animals who are in a difficult situation right now are also an illustration of the difficult situations that you find yourselves in, and that humans are victims in these cruelty cases too. So in that, our entire approach is really supporting the safety, justice, and representation of Indigenous nations and their communities, but while also advocating for those things for animals. And really changing the meaning of what criminal justice means, and using restorative justice and transformative justice and equity and representation in all of the work that we do. So who do we serve? We are the ones who serve Indigenous nations. They are our clients. They come to us. I don't impose myself on them because that would just be another form of colonization, but I work to build really strong relationships with Indigenous nations to know that we're there for them if they decide that they want to use the resources that we have to offer. We also have an expertise in animal law, and so we're ready and willing to use that expertise when it feels right to clients, not trying to push advocacy in a wrong place and perpetuate further injury. I know Gussie has a different, perhaps, audience of animals that she supports and she represents in her work. For us, the animals that we focus on are animals that have any relationship at all with Indigenous nations, particularly on reservations. So that might be work with humane population of wild dogs or community dogs on reservations. That could be wildlife, horse populations, also companion animals and animals in farmed situations. Some of the projects that we've done recently, we draft ordinances for Indigenous nation clients, really for animal cruelty as well as animal regulation. We've worked with environmental health departments to work on licensing and also revisit federally suggested language for dangerous dog legislation to make it more humane for the animals and the dogs that would be put up and compared to that. We also do legal strategy development because the Indigenous nations of the United States have a very special relationship with federal government, and because of this, their histories have access to rights that states might not have. We are developing legal strategies to be able to get different resources to Indigenous nations that through different waiver systems and programs that might not be offered otherwise, and also help humanely manage populations of animals, but also promote the welfare of animals and humans as well within reservations. That also leads to article publications to get the word out, and also in a lot of collaboration with other animal advocacy organizations that have the similar missions. We also support proposed state laws that advocate for uplifting animals and members of Indigenous nations and reservations, but we also work to vocally oppose laws that do the opposite. And then I think this is one of the most important points, besides the last one. We really work to develop long-term relationships with elders and representatives of Indigenous nations and collectively, because these different types of projects are years long. This isn't something where you insert yourself, you do work and you leave. You work with leaders of Indigenous nations to find out what they need through anti-colonization or a decolonization process, you stay there, you have the same people there so that they can trust you and they know that they're not being used or objectified in ways that they have in the past. And then thanks to very generous donors, one in particular, we have scholarships for students who come from Indigenous nations or multiple Indigenous nations or have a keen interest in Indigenous nations in their law school work. And we actually have a wonderful cohort that's here today. Thank you to those generous grants who are here for that focus. I wanted to give you Janet's contact information in case you did want to learn more about ceding sovereignty and reach out to her. And then if you have any questions, please feel free to contact me. The whole focus of all of this work is to work towards an anti-racist approach of the animal movement. I know everybody who's in this room has compassion and love in their hearts, and they're doing everything that they can to advocate for animals, as well as understanding the interconnections between animals and the social justice movements. The First Nations need as much advocacy as animals do, and not in a way that's conflating, but recognizing that communities that are marginalized and have had very deleterious histories and atrocities committed against them need to be recognized and also respected for their long-standing traditions and histories and the vibrant communities that they have today, but also recognizing that because of the relationships that have occurred and also sometimes misguided efforts of advocating for animals, sometimes requests for advocacy can have racial undertones or ignorant undertones. And so the ability to learn more and know what you can do to help in a way that uplifts members of Indigenous nations and Indigenous nations collectively is not only advocating for animals, but it's also advocating for a more just world. Thank you. And with that, I'm going to transfer this over to Gussie Lord, who is our next speaker, and she's going to be virtually presenting.
Hi, thanks everybody. It's good to be here. Sorry I can't be there in person. What I wanted to talk to you about today was tribal treaty rights and how they intersect with off-reservation animal conservation. In particular, we're going to talk about the gray wolf. And this is a species that management of the gray wolf has been overtly political and not necessarily tied all the time to conservation of the species. There's been other issues at play here. Also, just a quick overview, as Jessica mentioned, I'm the managing attorney of the Tribal Partnerships Program at Earthjustice, and we're an environmental nonprofit organization. We focus mainly on litigation, and we bring all pro bono pro-environmental cases. Figure this out here. So Jessica gave you a little bit of an overview of federal Indian law. I'm going to do federal Indian law. I like to call this 500 years of federal Indian law, 4 minutes or less. So Jessica mentioned, federal Indian law just governs the relationship between the United States and tribal governments. Tribes are political bodies. They have inherent sovereign authority, which means they derive their authority to govern from themselves. This isn't anything that was bestowed upon tribes by the federal government. This is an inherent tribal inherent feature of being a self-governing body or self-governing group of people. Tribes were written outside of the Constitution because they existed before the United States government did. Again, as Jessica mentioned, today tribal sovereignty is somewhat limited by the federal government, so tribes generally have to comply with federal laws, not all federal laws to the full extent, but for the most part they have to comply with federal laws. And they're also subject to congressional plenary authority, which means Congress has the ultimate authority over tribal governments. And, for example, can terminate tribal governments, which is what they did in the 1950s. States have very limited jurisdiction in Indian country, not entirely, but very little. And tribes, although they have jurisdiction over their own lands, that's somewhat limited as well. For example, tribes often don't have jurisdiction over non-Indians or non-Indian businesses operating within the reservation borders. So one of the things you might hear, a term you might hear is the federal trust responsibility. And what that means is because the federal government holds some of tribal assets in trust for the benefit of tribes, they have a fiduciary duty to tribes to take care of those resources. Sometimes those are water resources or land resources. Sometimes those are animal and plant resources. And so what does that mean? How does the federal government have to treat those resources that it holds on behalf of tribes? That's the trust responsibility. So again, a little bit more on background before I get into the case law about the wolves in Wisconsin. I want to talk about tribal treaty rights and what those mean. Tribal off-reservation usufructuary rights means that tribal citizens have the right to go off-reservation and hunt and fish and gather and access certain bodies of water, access certain cultural sites off-reservation. So tribal treaties, again, are federal law. They're on par with the Constitution and federal statutes as the highest law of the land. And another thing that's important to understand about treaties is that they reserve rights to tribes. They're not a grant of rights from the tribal government or from the United States government to tribes. They're a reservation of existing rights that tribes had, either land or hunting and fishing, or other rights to practice their culture that tribes reserve to themselves. And that's where you get the term reservation from. And anything not explicitly ceded by the tribes in a treaty is reserved to the tribes. So as you see on the map here, there is a series of treaties in the Midwest between the Ojibwe bands and the United States. The treaty areas I'm going to talk about today are the 1837 and 1842 treaty territories. You can see in the Wisconsin, sort of the upper third of Wisconsin, those two different green areas are the areas we're going to talk about with regard to wolf conservation and tribal treaty rights. So the treaties that the Ojibwe bands entered into in 1837 and 1842 limited, the tribes ceded a bunch of areas and limited the areas that the tribal folks could live on, but the tribes reserved to themselves the ability to hunt, to fish, and to gather in those ceded territories. So as Jessica mentioned, when tribes are being sort of relocated and limited in their jurisdictional scope to reservations, they also didn't really, for the most part, have access to the courts. A lot of folks were sort of confined to reservations, either explicitly or sort of implicitly. But as the years progressed and into the 1900s, tribes started trying to enforce the treaty rights that they knew they had. Saying, wait a minute, we're allowed to fish in Lake Superior. We're allowed to hunt on state land in Wisconsin, and they had to go to court to sort of enforce those treaty rights. The original cases in the early 1900s often weren't successful, but sort of toward the middle of the century, tribes across the country and certainly in the Midwest started winning those cases. I think it was 1972 that two of the Wisconsin Ojibwe bands had their rights to fish in Lake Superior recognized. And in 1983, all 6 bands of Ojibwe in Wisconsin, the named plaintiff was the Lakota Band of Ojibwe, Wisconsin, got the recognition of their treaty rights upheld in the 7th Circuit. And that was under the Treaty of 1842 and 1837. And basically the holding was that later treaties and later removal acts didn't extinguish those off-reservation treaty rights. As you recall from the earlier slide, part of the 1842 or 1837 territories in Wisconsin or in Minnesota, and in 1999, Minnesota Ojibwe had their rights recognized, their off-reservation hunting, fishing, and gathering rights recognized in the Supreme Court. So basically, that case, that 1983 Voight decision in Wisconsin, was really the linchpin for the Ojibwe bands in Wisconsin to start exercising again their off-reservation treaty rights. If any of you were around the Midwest in the 80s and 90s, there were a lot of sort of extreme fights about fishing, about the extent to which tribal folks could fish off reservation, not subject to state regulation. And some of those controversies got pretty heated. But anyway, they were vindicated in the courts. There were several iterations of the Lakota Ray litigation that really determined how much the tribes, the tribal citizens, could hunt, fish, and gather off reservation, what the state's right to regulate that activity was, and just sort of how that federal responsibility to the tribes, how those rights recognized under the treaties, how those rights conferred to the tribe, how those rights confirmed by the treaties, how those played out when state jurisdiction comes into play. So in Wisconsin, it's, you know, the conservation department, the Department of Natural Resources, that regulates hunting and fishing and regulates public use of the land. So the state authority is over the off reservation rights, but it's a federally guaranteed right of the Indians off reservation. So you've got all these jurisdictions coming into play. You've got these different interests at play. And so how does that play out? And so fishing was a big one. A lot of the different species were sort of parceled out differently. For example, deer hunting in Wisconsin, the tribal members can't possibly take half the deer. So that's a little bit of a different scenario. But for most of the species, it was determined that tribes are entitled to half of the take of the species within the ceded territory, within that green part of Wisconsin. So that includes wolves. So the gray wolf is a really interesting species in terms of conservation, because there was so much fear around wolves, and there was really concentrated efforts to eradicate wolves from the landscape. There were bounties on wolves. You know, people just killed for sport. They killed them because they were afraid, because they wanted to protect livestock. They wanted to protect their hunting areas from wolves. And in 1959, the last recorded wolf was killed in Wisconsin. There were still probably a few in the very far northern reaches of Wisconsin, but wolves were largely eradicated by the late 50s. And the wolves were one of the species that were put on the Endangered Species Act in the 70s when the Endangered Species Act was passed. So through the 70s, you know, wolves were protected. There were small populations left in northern Minnesota and northern Wisconsin, and they really started to regain their place on the landscape, and the health of those populations really rebounded. And they started to migrate down further south in Minnesota, across Wisconsin into upper Michigan. And so those populations really started to recover. But in 2011, they were delisted from the endangered species list. And some of the attorneys in my organization, Earthjustice, filed suit and sought to have that determination undone, because the belief was you can't just look at the wolves in one part of the country and say, oh, they recovered. You have to look at the species across the entire landscape and where they used to be, and the range is very much reduced. So that decision was overturned in 2014, and it was determined that it was improper for Fish and Wildlife Service to delist gray wolves because they weren't fully recovered, and they regained Endangered Species Act protection in 2014. So in the meantime, Wisconsin did hold a couple of wolf hunts, and they also enacted a statute requiring the state to hold a wolf hunt if wolves were not on the endangered species list. So then in 2014, they regained, you know, protection, so they're protected. And then under the previous administration, wolves were delisted once again by the Fish and Wildlife Service. So in 2021 of January, wolves lose Endangered Species Act protection, but because of that statute in Wisconsin requiring a wolf hunt, Wisconsin immediately implemented a wolf hunt in the state. So Wisconsin DNR had intended to hold a wolf hunt in fall of 2021 after they were delisted. But Hunter Nation, a Kansas-based hunting rights organization, sued Wisconsin and said, you have to hold a wolf hunt immediately. It doesn't matter that they were just delisted, you have to hold a wolf hunt, and they won. So Wisconsin was forced to go forward with holding a wolf hunt, despite the fact they were unprepared. They hadn't done a full population survey, which they wanted to do prior to implementing wolf hunt. And so they didn't really know what kind of impact a wolf hunt was going to have on the population. Nevertheless, they issued 200 tags, so 200 wolves could be killed. And the Ojibwe bands, the 6 Ojibwe bands in Wisconsin, opposed the wolf hunt. They don't believe that you should hunt wolves. They wanted to try and protect as many wolves as possible. So they said, you know what, half of those tags belong to us by treaty. If you're issuing 200 tags, then we get half of those tags in ceded territory, which means almost as many, almost half, because most of the wolves are in the northern part of Wisconsin. So the tribes asserted their right to half those tags, and Wisconsin held the wolf hunt anyway, and the wolf hunt just went way overboard. Wisconsin hunters killed all the wolves that they were allowed to kill, and then, you know, again 100% again, so took way over the state share and then the entire tribal share, and then some within just a couple days. And there were a couple of reasons for that. One of which was later in the season, and there was snow on the ground. It was easier for dogs and hunters to track wolves, where normally the season would be in the fall, and they would have a little bit better a chance to get away and to hide. But it was just a little bit overboard, and the Ojibwe really were incensed at how this was carried out with the state's blessing and the state's oversight. And so the tribes considered this to be in violation of their treaty rights. They had the right to have the wolves. The state was supposed to protect at least their share, and they didn't do a very good job. So a little bit about the Ojibwe worldview with regard to wolves. I'm not Ojibwe. I'm not really qualified to speak to their beliefs, but I do know the Ojibwe word for wolf is Maingen, and that the Ojibwe believe that a wolf is the brother to mankind, that the wolf has cultural and spiritual significance, the Ojibwe people, and that what happens to the wolf happens to us all. And so in the late 1800s, early 1900s, when tribes were being driven from their lands and dying in large numbers and succumbing to sickness, that's what was happening to the wolves on the landscape as well. And as the century progressed and tribes started to regain their footing and wolves regained their footing on the landscape as well, the Ojibwe saw parallels in what happened to the wolf population, what happened to their own populations. They believe that where there are wolves, there is, there's game, and there's, good hunting, and there's good, ecosystems, and that the wolves have a place in the ecosystem. They're an apex predator. They shape the ecosystem. They support biodiversity. They take the sick animals and really contribute to the health of the ecosystem as a whole. So the Ojibwe really believe it's very important to have the great wolf there on the landscape and to regain its footing on the landscape in the same range that it used to be. So a lot of Ojibwe bands in Wisconsin have adopted wolf protection plans. There's no reservation in Wisconsin where you can hunt wolves. They're protected in all the tribal areas in Wisconsin, but they're really wide ranging. Even if they have dens, or even if their main area is within a reservation area, the wolves don't know, the jurisdictional boundaries, and they come on and off the reservation. So it wasn't possible for the tribal governments and the tribal wolf management folks to protect their on-reservation wolf populations. So it's something they really have to work with the state. And there's a real disagreement. Obviously the state laws say there must be a wolf hunt, and the tribal laws say there can't be a wolf hunt. So there's a disconnect there when the population is moving on and off reservation, in and out of tribal and state jurisdiction. There's a real disconnect between how the Ojibwe populations and how the state populations think that the gray wolf should be managed and conserved. So after the wolf hunt in 2021, which happened really quickly, the tribes didn't have a chance to intervene and try to prevent that. But the state was going to move forward with the second wolf hunt in 2021 in the fall. And the tribes are really incensed again at the way the February 2021 hunt had been carried out. And so the Wisconsin Ojibwe band sued the state of Wisconsin in hopes of preventing a second hunt in that same year that there was, sort of indiscriminate slaughter of wolves in February. So the tribe said, look, if you have a second hunt this year, you don't know the impact. You didn't know the population before you issued those tags. You don't know the impact of the population that hunt had. Those were just the wolves that were reported. They thought there were certainly other wolves that could have been killed and not reported, or were shot and never recovered. And so they believe that, look, state, you have to do a much better job of figuring out the population before you implement a second hunt this year. The second they're removed from the endangered species list. There was some shenanigans at the state level. Some Wisconsin officials that were in charge of setting the quota for a wolf hunt were saying, okay, well, we know the Ojibwe tribes aren't going to take their quota, so let's just set it at twice the number of wolves, because they know that the tribe isn't gonna use their tags to kill wolves, which is also, we believe, an impermissible violation of treaty rights. So one of the things that the tribe sought in this lawsuit was a ruling that the right to hunt and the right to fish and the right to gather also inherently includes the right to conserve. And I think that's going to be, we don't have a case, there's not a case on the books that says that. It just says you have the right to hunt. And certainly Wisconsin took the position that, you only have the right to hunt. You don't have the right to say, we don't want to hunt our quota. And we certainly think that's not true. The tribes have sovereignty over their portion of the animals and the fish and the plants. And if they don't think that those should be hunted or taken, then that's their right to conserve or to manage those populations as they see fit. So that's what one of the parts of the lawsuit sought a ruling that the right to hunt includes the right to conserve. And I think that's going to be more and more important as we see biodiversity crisis happening, as we see fish populations plummeting, as we see animals habitats contracting. It's going to be really important if tribes can say we have the right to conserve. We have the right to include our management practices for off-reservation populations. And so it's a little bit anticlimactic because what happened was this hunt got stopped on other grounds. There was our case was in federal court on treaty rights, and there was a state law case that was brought on the state regulatory scheme. It was an insufficient regulatory scheme. They didn't actually have any final regulations in place to regulate the hunt. So a state court judge stopped the hunt, and then we'll sort of relist it on the endangered species list in 2022. So super interesting and important case. We didn't actually get to bring it to conclusion because wolves are now re-protected on the endangered species list. But we do have some concerns about what happens next. So there haven't been any further hunts in Wisconsin or anywhere else. Or there might have been some in the Northern Rockies populations, but there weren't any more hunts in Wisconsin, at least since they've been relisted on the Endangered Species Act or list. But we know the Fish and Wildlife Service is looking at this again, and it seems likely that they're probably going to remove gray wolves from the endangered species list probably in 2024. There's also a number of federal laws that have been introduced by Wisconsin and other Midwestern legislators, some Western legislators, to delist wolves legislatively. And that's going to be harder to challenge. If Congress passed a law that says wolves aren't endangered, there's not a ton we can do about it in court. In the meantime, Wisconsin's moving forward with wolf management plans. They're seeking to, rectify those regulatory issues that stopped the hunt in 2021, the second hunt. And we're just trying to keep watch on what's happening through Wisconsin DNR. There's a law that was passed, I believe, by the state Senate in Wisconsin this week, requiring DNR to set a cap on the number of wolves. You can't have any more than X number of wolves in the state. Again, you see the difference between the tribal sort of wolf management plan and wolf protection plans and the state requirement. You can't have any more than this number of wolves, which, I mean, there's inherent problems with that. How are you gonna know how many wolves are in the state in one time? You can't say that you can only have this many deer, this many fish. But anyway, we'll see how that goes. And the tribes in Wisconsin continue to regulate their members in off-reservation hunting, fishing, and gathering. Great Lakes Indian Wildlife Commission is a great organization. They have a lot of information about these and other issues on regulation of off-reservation treaty rights in the Midwest as a whole, if you're interested in more information there. So that's pretty much what I wanted to talk to you about today. I think it's kind of an interesting issue, an interesting confluence of both federal Indian law, federal Indian rights, and tribal and conservation. And particularly, again, for a species like the wolf that has been so controversial, and that has been really a hot button issue. People really get fired up about wolves. And we do too. Earthjustice lawyers have been fighting to protect wolves for, I think, about 30 years, and we'll continue to do so. And we're especially glad to be able to represent tribes in their fight to apply indigenous ecological knowledge to conservation practices. We think that should be more widespread. And we're just here to support our clients and support the wolves. Thank you very much.
Thank you so much, Gussie.
We'll now turn to questions from the audience. If you have a question, just like the previous session, please line up behind one of the 2 mics at the front of the room. And those joining us virtually can submit questions via the Q&A icon at the bottom of your screen. Also, Megan will be asking the questions from the virtual participants, and she will hold up a sign so I will be able to see those. Thank you. Anybody feel free to come up.
Question regarding how we can or some solutions to promoting animal law while also protecting indigenous nations.
So I think what I'm about to say, you can certainly look at as a broad expanse. Sorry, this mic is having some issues. So know that I'm going to focus this on First Nations and Indigenous nations, but I hope that you also keep this in mind for, I hope that you also keep this in mind for when you're also working with Black and Brown communities and groups of communities that have been traditionally marginalized. The biggest issue that I've come across in cruelty law is the fact that in so much of our recent animal law history, federal government has enacted legislations, states have enacted legislation that just seems to create an uphill battle for us. And so oftentimes what happens is we see animals suffering every single day and we don't know how to help them. But what happens, thank you, Anne-Marie. What happens is that when we see that suffering, we assume that everybody who's committing this suffering is of the same type and is a bad guy. But sometimes when we see the suffering, that's all we see. And we don't look at the communities that are also suffering in the capacity of how these legal systems, our infrastructure is actually impacting them. So what happens is, going back to that One Health perspective, we see something that we think is cruelty, but it's really a lack of access to veterinary care. Or you see people who may be committing cruelty, and this ties into my other work, but really they're suffering from extensive amounts of trauma that they've never had diagnosed or helped with. And I would argue animal cruelty is sometimes a symptom of trying to manage that trauma that doesn't exist in those symptoms. And so what happens is we, because no one really listened to us in the past, we try to, enforce, jail time or fines or something that we think will really bring notice to the world. And for a lot of people who commit cruelty, those, I'm never going to advocate for incarceration for most cases. I think there are a lot of other options, but there are traditional ways that might make sense. However, for people who belong to Indigenous nations and other groups that have been marginalized, they're dealing with levels of oppression that you might not even be able to understand because your background is different than theirs. And so a way that you can uplift animals and advocate for them and also uplift these groups of people and communities that otherwise get vilified many times and have further oppression through the traditional legal system is by looking at why the cruelty or the neglect or whatever you might have identified as violative of the legal system has occurred, and say, is this a poverty issue? Is this a mental health issue? Is this a resource issue? And rather than trying to force a legal system that may not be, first of all, isn't going to be natural for a particular nation or culture, but also doesn't necessarily resolve the underlying causes, I recommend that you work with the community that you're seeing the cruelty in, or that you're seeing what you think might be cruelty. And also work with nations and recognize their legal systems and say, how can I be part of the solution and not contribute to a problem that may put a Band-Aid on that cruelty in the instance, but then actually causes further turmoil and injury to the community at hand. I would also recommend that we take a step back and know that we couldn't have existed, the animal law couldn't have existed without all of the civil rights that have occurred before us. And so if we can look at strategies of how different civil rights movements have uplifted the peoples that they've represented, see how we can apply that to animals as well. But then also realize that the movements and the tools for moving that forward are one and the same. And so in that way, you can also use those tools to represent animals, but also realize that you're also fighting for civil rights and uplifting the peoples that are also in this situation and maybe thought as contributing to the problem, but are actually providing the answers for what we can do better to bring everybody into that successful, healthy One Health circumstance.
Hello.
Oh, yes.
So it seems that there's a lot of jurisprudence and it goes back and forth to the levels of self-determination and deference that the tribes actually have in different areas of the country. Can you go into the factors that lead into that? Because it's not clear whether or not the Endangered Species Act actually applies to each tribe. It seems like it's more of a case by case level.
Yeah, is Gussie still here? She might be able to answer that
Yeah,
even more
I'm here.
accurately than. Okay, perfect. Gussie,
Sure.
did you hear the question? Otherwise, I can ask the student to repeat it.
Yeah, I got it.
Okay.
So yeah, that's actually that's a great question, and it isn't clear. I think I mentioned earlier in the presentation that for the most part, tribes have to comply with federal law, but that's not always the case, because sometimes if federal laws don't explicitly apply to tribal areas, then it's not super clear. Like, for example, if you were going to make some area a critical habitat, that might infringe on the tribe's sovereignty to use that area for other purposes. So it hasn't been clear on how the Endangered Species Act applies in Indian country. There is a secretarial order that tries to clarify it, but there hasn't been a ton of clarity in that one area, in the area being, how does the Endangered Species Act apply to Indian country? So a lot of times tribes and the Fish and Wildlife Service just work together. A lot of times the tribes have to use their own resources to do that, to implement a recovery program for a specific species. A lot of times tribal areas are less developed. And so one of the main drivers of species biodiversity, limitation on species biodiversity is lack of habitat. So sometimes if there's better habitat in Indian country or less development, sometimes that occurs, on a somewhat more natural basis. But a lot of times tribal areas are limited in scope and jurisdiction. And so a lot of times, again, tribes will just voluntarily implement plans to help restore an area for a specific species. I think black-footed ferret was one of them. I think you're seeing a lot of bison restoration activities in the Great Plains areas. And then one thing that we're pushing for, and a lot of our clients are pushing for, is greater incorporation of tribal co-management on public lands, on federal and state public lands, implementation and application of traditional indigenous knowledge in federal and state land management, and like I mentioned today, state conservation practices. So again, it's not 100% clear how the Endangered Species Act applies in Indian country. A lot of times it is on a case-by-case basis. And certainly we're pushing with our clients for greater levels of involvement from tribal governments and tribal environmental professionals in state and federal land management practices.
Thank you both. And this question is for both of you in general. In talking with animal law counterparts around the world, it's become increasingly clear to me that one area that American animal law largely ignores is community dogs. And there are two circumstances in US jurisdiction where that is not necessarily the case. And that would be community dogs in the territories and res dogs on First Nations reservations. And I'm wondering if you have any comments on the plight of those animals and the way the law either accounts or doesn't account for them, and what we can do. Thank you.
Thanks, David. And if anybody isn't sure what community dogs are, at least from our experience with working with Indigenous nations, that they are dogs who are very loved, and they just don't happen to live inside a specific house or home. They tend to have multiple families that they consider their family, and they will go between homes and have a wonderful life. They live outside. But they're not stray dogs and they're not wild dogs. They're really part of the community, and they're just another layer of just being outside and in that capacity. Right now, the legal system, at least for the US, doesn't really address that. However, particularly in like US territories, these dogs are a way of life. changing that perspective by trying to remove these dogs and find homes is something that a lot of people are actually very against, because they're part of their community. They see them every day. They're considered family. And so what we've actually done is I've drafted legislation for community dogs that's customized to the particular Indigenous nation client we were working in the moment, so that we could account for and create protections for community dogs, including dangerous dog laws, and being able to protect them from cruelty, but also being protected from removal, particularly from state jurisdictions if they came over, but also protecting animals from being taken. A really great example of how do we advocate for animals but hurt Indigenous nations is a situation that happens on quite a few reservations, where animal advocates think they're doing a really great job because there is a large dog population on a reservation, and there is definitely an issue with many Indigenous nations having dogs that have injured their members, and so that's a really very clear One Health project problem that we can talk about. But then what happens is advocates see these dogs that they think are stray, they're not loved, they don't have homes, and without asking permission from Indigenous nations, they take them home and they remove them from these reservations and then rehome them. But little do these people know or care to ask, these members of the community were also family members and oftentimes loved. And so we create legislation that protects the dogs from being removed, having consequences from outsiders that come in and remove dogs, and also force advocates to work with leaders of Indigenous nations, whether it's the Department of Health and Environment or the tribal council, to make sure that they have permission to be on the land and not take what is not theirs and what is also very much loved. So it's our effort, particularly because the US legal system is what's being imposed. It's our effort to be aware of those situations and understand what the need is, and then draft legislation that's customized to the Indigenous nation and that they can use and adapt, but then also protects the very animals and the humans in that circumstance that love those dogs very dearly. So we're doing legislation. I'm sure that with more heightened attention to this, there will probably be litigation surrounding this. There are a lot of custody issues surrounding that. So looking forward to protecting dogs and humans in that way. And I don't know if Gussie, if you have any comments to that too.
No, I think that's more your area. Thanks, Jessica.
Okay, perfect. We've got 4 minutes. Oh, perfect. Altamash.
So the first thing that I just wanted to say that has to be said was actually, I really loved the calm and the integrity you had in your voice. It really tells like, this is so passionate to you and you're really leading this effort from the heart. Just wanted to say that. And the question that I actually had is about history. The research, that the work you're doing is actually implies that as humans, we think that history actually began with us. And even in humans, we particularly think that history actually began with people that are right here. And we forget that these Indigenous nations and these people, they were here before us. And the same trend is actually true for animals as well. As humans, we think it's our history because we wrote it, right? And we think that animals, they were not here before us or things like that. So I just wanted to ask, like, did you see this kind of a trend in other areas, like in a part of your research? And how do you think we should, address that? Because clearly history does not begin with humans. Thank you.
Yeah, thank you, Altamash. Thank you for that question. It's a hard one, and I don't know if I have enough time to be able to give an accurate, legitimate answer to that. And I also think that my voice is just one of many, and it's not also the one of authority, because I don't belong to an Indigenous nation that was here before the United States was. I think that there's a lot to play, and in respect to religion, different religions have different perspectives on the way that animals are treated. There's this idea of dominion and control with a lot of Western cultures of the way that we treat land and animals. And I think that we are moving away from that decolonization perspective, hopefully, and trying to find a way that creates balance with the world around us and with animals. And so while still respecting the religions that helped, found this country, but also respecting the Indigenous nations that came before us and the animals as well, there's going to be a shift. There needs to be a shift where you can still have those founding beliefs, because religion is so crucial for so many people. And there's so many other reasons, different philosophies, your background, your livelihood, your family's livelihoods for centuries. So many things go into your beliefs, but being able to make room to also have this part that was here long before we were and our mentalities. And so you can still appreciate and acknowledge the reasons and the factors in your background that have brought you to this place in your life that you are, but there also needs to be a recognition that everybody has a unique background and a distinct ideology about the way that they interact with the world. And so it's really a level of compassion and collaboration with everyone to create a future that entails all of that, and really just finding a way to live and let live.